judge has approved your request for an audio-video recorder. You may set it up at this time.
Afternoon, Judge.
Afternoon.
Set up.
He's over
Yep,
there in the corner, I believe.
Good.
And that's fine, sir. Good afternoon.
Okay, Adam Mackler versus Curtis Fenimore and Robin Mozingo.
Plaintiff is here.
All right, and remind everybody you're still under oath. If you could just all be seated, that'd be great. Thank you. Now, I took a moment to go through the file. I believe I had some interest in learning a little bit more about who actually owns the property. I expressed concerns about a lease that appeared to be interesting, to say the least. A 99-year lease at $100 a year. I think that's what I was told. And I now see there have been a number of motions regarding discovery. There have been some interrogatories, there have been motions to compel, motion for exclusion of witnesses, a number of things that I'm looking at. And I think I'd like to address those in a preliminary way. I know that the defendants apparently have responded to some interrogatories, is that correct?
We respond to all his discovery requests, Your Honor.
And they're suggesting, Mr. Mackler, that they requested discovery on you and you haven't done anything or given them any discovery. Maybe you could comment on that for me, please.
Yes, Your Honor.
I could keep this.
At the outset, I'd like to say I got all my discovery requests to them within about a week of their continuance, which was granted at their request. They got a 30-day continuance, and they waited 3.5 weeks to deliver their discovery request to me. So I had no control over the deadline. If the deadline happened to occur after today's hearing. I am not trying to conceal any information from them, anything discoverable. I made my best effort, and I did get all their discovery requests to them today. If I could have done it sooner, I would have.
No, I appreciate that. And sometimes these things, it's the famous chicken and egg, you know, when do you get it, when do you respond, and so forth.
For their part, I do have problems with their responses. They declined to answer a number of my questions.
Well, then there are rules for that. There are certain things that you can do in accordance with the rules. I'm not here to give legal advice, but I'll just tell you that I expect full and complete responses if you're being asked. One of the things, regardless of discovery, that I have been concerned about at the outset from this is, and let me be direct about it, are you the proper party to be bringing the action? I've expressed concerns about the lease. I've expressed concerns about who actually owns the property. And when I referenced through the materials, I noticed that this fellow, this name keeps coming up, this Mr. Trombley, I think, is who, and apparently he's here. Good afternoon, Mr. Trombley.
Nice to meet you.
This Jacob Trombley was apparently the owner. I have no deeds. I don't have anything here in the file that would show me who owns what, who's who. I don't recall, and I'm not saying it isn't here, so I want to apologize in advance. I was going through the more recent correspondence on what is getting to be a thick file. The lease, this 99-year lease that was entered into, I expect there probably is one available. I don't remember seeing it. And again, I'm coming through here just for a moment, but I don't recall seeing anything like that. So I'm going to allow, regardless of the discovery issues, what I may do is hear some information today. I may delay this one more time. Believe me, it's only going to be one more time, so everybody gets the discovery that they think that they need. But I've got to bring some conclusion to this. I want this thing to conclude in one way or the other. Now, there's also reference to Superior Court. What's that all about? Could somebody comment on that for me, please?
be happy to.
Go ahead.
Your Honor, I was in, before Your Honor, defendant against Deutsche Bank. Deutsche Bank has filed a foreclosure deed on this property, and there is currently a case between myself and Deutsche Bank.
So let me see if I can frame it in my terms. So Mr. Trombley was the owner, is that correct?
Yes,
He was the deeded owner?
Yes.
Does anybody have a deed showing Mr. Trombley is?
I don't have Mr. Trombley's deed, but I have the bank's deed.
I'd like to see that, and I'll see if we can't back in.
I believe that's
Just a second, please. It's what I mark it as the exhibit. Just show that to plan up, I want to see it. So take a look at it.
It's actually on that list right there.
Sir, please, don't talk. You know, when he's trying to review it, it's difficult to be listening to you and reviewing. So please give him that courtesy. I'll give you the same courtesy, okay?
I'm familiar with that.
All right. I don't know if I've marked any exhibits in this case prior to right now. I can't remember. I'm going to mark it as a defense exhibit. You will find the number, it'll be A, B, C, or whatever. Just take a peek at this for a minute if I could. So this was a foreclosure against Mr. Trombley and Mary Trombley, apparently, back, and the deed is executed on the 16th of June, recorded on the 17th. So I would expect that the argument between you and Deutsche Bank is whether your lease has a priority position over this mortgage deed.
Right, I'd be happy to explain that case in as much detail as...
Well, I'm trying to keep it as straightforward and simple for everyone as I can, but go ahead and give it to me. Give me the short version if you can, please.
Okay, three things. First, their eviction notice was deficient in that it gave a deadline as the termination date of the lease.
I don't want to get into the eviction notice. I'm trying to follow the ball on ownership. That's the first thing I'm looking at. And I'm trying to find out what the nature of your argument is with Deutsche Bank over in Superior Court. I think I know, but if you could tell me, I'd appreciate it.
Deutsche Bank has had 2 foreclosure sales, they say. They say they had one in December of 2010. They say they rescinded that, and then they had another foreclosure sale on April 20th.
That results in this deed.
Correct.
Well, I'm going to focus on what was the recorded deed that apparently transferred title to Deutsche Bank.
Right.
That's what I'm focusing on. So the fact that they may have stopped a foreclosure, failed to record a deed after foreclosure, which they're generally entitled to do, this is not particularly relevant to me. It may be relevant over in Superior Court, but I'm just trying to follow the ball. So what's your position in this? What do you go ahead?
On December 8th, before Your Honor, I was ordered to pay a recognizance to Deutsche Bank, which I've been doing since then, $1,500 a month, and that covers the building that these defendants are living in, and they're 4 months behind in rent.
Okay.
I'm paying for the apartment they're living in.
Okay.
And they're living rent-free, they've got nothing to lose, and every continuance, every delay is...
Which is why I'm going to do my best to get this going, but this is a fairly convoluted case. This is not my classic L&T where the owner strolls in and isn't being paid rent. I mean, even you will agree to that. But what's currently the dispute between you and Deutsche Bank? That's what I'm trying to understand.
I'm challenging that April 20th sale on the basis that they're saying...
You're challenging it because you believe that your lease has priority over their foreclosure. Is that the gist of your complaints with Deutsche Bank?
I don't believe that foreclosure is valid, or I have a question about whether it's valid. I want an answer from the
Well,
Superior Court.
Mr. Trombley is going to be the one that would be the one to complain about the foreclosure. You would ordinarily be complaining about the impact of the foreclosure on the lease that you entered into with him. Because as I understand it, you have a lease with him. He didn't deed it to you, did he?
No.
You leased it. So basically, you're saying, I've got this lease, Deutsche Bank, and when you foreclosed subject to my lease. I mean, that's sort of what I'm getting from you, because if not, your lease is gone, potentially gone. That's what I'm trying to understand here.
I want to know that that April 20th foreclosure sale actually happened and it's valid.
If this sale happened and was valid?
I have questions about that because of the rescission that they're saying happened.
Yeah, well,
And I have no details on that.
well, I'm assuming, I'm looking at the affidavit, it says that they caused the attorneys to go to the place and publish it, and they caused it to be sold.
But were they holding the mortgage on that day? That's my question.
The affidavit says they were.
Well,
I'm telling you, I wasn't there.
uh,
Were you there?
I was there on April 20th, yes.
What happened on April 20th?
An auctioneer showed up and.
Sold it. Well, it sounds like it happened to me.
Only if they were holding the mortgage on that day, just because some guy showed
Well,
up.
the problem here, let's get back to this. Here's the problem. I'm sitting here trying to figure out who the owner of the property is that should be paid rent. Let's start there, okay?
Is that not an issue for the Superior Court?
Well, that's the problem. See, you're saying, gee, Judge, get this resolved here, but I need to find out who the owner or the, let's say, party in interest is. And let me explain that to you. You may be the guy that should get the rent. Superior Court says, Deutsche Bank, guess what? You did a foreclosure that was illegal, or didn't happen, or whatever you want to use it. Or the Superior Court says, you did a foreclosure, but it does not, the term we use, lawyers just wipe out the lease that I had with Mr. Trombley. And again, I don't know much about that lease. Then the court could say, yeah, Deutsche Bank, you own it, subject to your lease, a 99-year lease. If you own the property subject to a 99-year lease, my view of the world is you're technically the landlord at that point. Because by statute in New Hampshire, a 99-year lease is tantamount to a fee conveyance, by statute. And at that point, I could probably say to these folks, if you want to stay there, well, I mean, if you're going to be paying rent. You can't be living for nothing. Nobody lives for nothing that I know of. If we are, I think I want a room in your place tonight. I want to go down there and, you don't mind me. It sounds like a good deal to me. But the concern I have is this tangled web of where we stand with you and Deutsche Bank in terms of the ownership / lease that you may have had. It's pretty clear to me that on the face of this document, Mr. Trombley doesn't own the place anymore. On the face of this document. On the face of this document, Deutsche Bank bought it at foreclosure, which they're entitled to do. They're the owners. And when they became the owners of this property, then they're the ones that are entitled to get the rent. Now, caveat. The new person who bought the second doesn't pay the first can come in and foreclose. He can come in and foreclose and take the property. So you can have very interesting dynamics dealing with these foreclosures. So the problem I've had all along, is who is the proper owner. By deed, Deutsche Bank should be sitting there saying, these people aren't paying rent, Judge. We want them the heck out of the property. Or they've got to work something out with us, so they got to leave. And if they weren't paying rent, I'd throw them out. It's that simple. Go ahead.
Deutsche Bank actually did commence eviction proceedings, did serve a notice on these very defendants here, and they filed no appearance.
No, they did not.
Whoa, wait a minute. That's not before me. That's not before me today. What's before me today is your efforts to evict. And I'm telling you that you may have the right to do so. I've never said that you might not. My concern always has been is we basically have what is generically referred to in the law as a form of plea of title. You think your title by your 99-year lease is better than Deutsche Bank's title as a result of their foreclosure deed. And unfortunately, that's a Superior Court matter. You're absolutely correct. And until I know that I'm dealing with the owner, and it could be you under your 99-year lease, or I'm dealing with Deutsche Bank, under their foreclosure deed, I'm sitting here paralyzed. I'm paralyzed.
Can I make a suggestion?
Oh, I love one at this point, because I'd like to get this moving. I'd like to get this off my docket. As much as I like all you folks, you're a good group of people. I'm fascinated by the issue, by the way, but unfortunately, fascination doesn't equate into a good ruling that has some basis in the law. But go ahead, give me the suggestion.
The defendants are saying that the reason they're not paying is because they don't know who to pay.
That's not what we're saying, Your Honor.
Well, we'll let them speak for themselves in a moment,
Yeah.
but yeah, that's your kind of assumptive rhetorical statement. But go ahead, I accept that. Go ahead.
At this point, because I'm paying the recognizance to Deutsche Bank is at no risk of me taking rent away from them.
That may be true. That's true.
And the defendants are at no risk of paying the wrong person because I'm not going to be able to keep it. In fact, I'm already in the red paying for the apartment that they've been living in rent-free for
Well,
5 months.
So you want them to pay who?
I would like them to pay an escrow, put their full arrearage in escrow, and allow me to withdraw funds to pay Deutsche Bank.
I don't know that I can order that. That's something Superior Court can order because that's an equitable remedy. If I order against them, let me tell you where recognizance comes in. If I order against them and they want to appeal it, then they have to post recognizance. But at that point, I know who I'm dealing with. So I'm not at liberty to issue an equitable restraint or distraint, if you will. You could file a motion with Superior Court. Why don't you?
This is much faster.
But I don't have equity power. This court is not a court of general jurisdiction. This court, every time I wake up though, we get people in here daily who think we're an equity court, but we're not. We don't have the power. We have the power to operate under the statutory guidelines that have been given to us as the so-called, well now it's a circuit court, but it's basically the district court division. And under the statutes, I can require recognizance in some situations. There are situations, but I do not have general power just to order recognizance. Superior Court does. Okay, I'm going to let you know that now.
Well, it does seem wrong that they should just be able to continue.
Well, wait a minute, yeah. And they could be responsible for a big chunk of it. If they had any, brains, they certainly have brains. They're nice folks. They've been here. Haven't been too disruptive, thank you. But yeah, I mean, at the end of the day, the court could come in and say they owe back rent for the last how many months and force them to pay it. But they're going to order that to be paid to the owner. The owner. And that owner could be you under your 100-year lease. I'm letting you know that now. But that's not for here. That's not for me to decide today. Today, I'm looking at an eviction where one side is saying, Judge, throw them out. They haven't paid rent. And if I were to order that, which I'm not going to, then at that point, Mr. Fenimore, I got that right? I mispronounced his name. Mozingo, at that point could appeal it, and at that stage of the game, they would be providing a recognizance to the owner. Okay? Well, that's pending. The problem I'm having now is a bigger issue, and that issue is the following. If I order them to start paying somebody, that somebody could be the wrong person and they get to pay twice. I'm not going to put anybody in that position. It's unfair and I won't do that. Likewise, as far as recognizance is concerned, you've got do you have what, a plea of title over there with Deutsche Bank and Superior Court? What's the status of that?
We've had a structuring conference, we've got a trial date set, and we're in discussion.
You know, I look at it this way. Let me explain this. The one thing Deutsche Bank and you both have in common is having them pay recognizance. That's the one thing the two of you could agree to. Just so you know. That's the one thing you could agree to. Because in the paperwork I have, it's either you or Deutsche Bank. It's either you or Deutsche Bank.
I'm concerned Deutsche Bank is going to not cooperate with me because...
I can't, sir, I can't force them to cooperate with anybody. I'm just letting you know that it seems to be one point that both of you could agree on. Because again, I don't believe these people should be living here for nothing. I'll state it for the record, I'm stating it now. But the problem is I'm powerless to act at this point because I need to make sure under the statutes it's crystal clear. In fact, part of the certification to even to bring an LNT is you're certifying it that you're the owner of the property. Right now, the best evidence of ownership that I have is Deutsche Bank. That's the best evidence of ownership that I have. Ownership.
The order that you signed for me to pay recognizance, I believe the court could.
You were a tenant then. See, at that point, you're a tenant. At that point, I can order recognizance to the owner in that instance.
But doesn't that, during the period that I'm paying that recognizance, doesn't that make me the owner until the case that the recognizance is
No.
covering is resolved?
It makes you a tenant that's appealing something to another forum based upon plea of title. That's what it makes you. I've been giving a lot of legal advice here. I shouldn't be giving too much legal advice, but I'm trying to clarify some of these issues. No, there's no reason for you to say too much, Mr. Fenimore, because this matter is going to have to be delayed once again. When are you going to get the Superior Court thing resolved?
August?
Well, I suggest, sir, that you're going to have to go to Superior Court if you want recognizance. I don't believe that that's appropriate in this case at this point because I have not made an order that's appealable, and that's the time recognizance would be ordered by this court, and I would order it if I were able to order it. Right now, I am in a position where I do not know who the appropriate party to pay recognizance is, whether it's Deutsche Bank or you. I don't know. I can't answer that question.
Can you relieve me of this $1,500 a month that I have to pay for the apartment they're in?
I would want to have a hearing with Deutsche Bank. If you want to request a motion for a hearing, I'll look at it. I'll look at it. That's for you and me. That's got to do with these folks.
Okay, because that's an extreme...
That's between you. If you want to file a motion for further hearing between you and Deutsche Bank, I will gladly hear that. But I want to notify them. They're entitled to be notified. They're entitled to comment on it. You know, I did the best I could with what information was available at that time. But if you'd like that further review, you want to file a motion to reconsider, go ahead. I'll be happy to look at it, send a copy to Deutsche Bank, and I'll tell you I'll schedule a hearing for you.
Okay, I appreciate that.
Now, you folks are still in, I don't know, you're out in outer space, you're in the backside of the moon, I guess. Not much I can say to you folks, because I can't do much with this until I figure out who the owner is, so that I can determine that the proper, quote, landlord, whatever that means, is bringing this action. So I can't do much. If Deutsche Bank and Mr. Mackler collectively get together, they could put you out of the house. I'm gonna flat out tell you that. I mean, well, barring anything else. As far as the rent is concerned, I don't know what to say to that, but I'm not making an order today because I don't believe I can appropriately order it since it has to go to the owner. I can't put you in a position of paying rent twice. I won't do that. I can't do that. The court is not going to do that. So what I need to do is continue this. Mr. Mackler, you can file your motion, but basically you need to get your issues with Deutsche Bank resolved before I have a clear shot. Now, if Deutsche Bank feels these people are their tenants, they can bring in LNT, and maybe we'll be having the same conversation with them. I don't know. If the two of you want to get together and collectively bring an action, the court could review it at that time. I think I've said enough today. Any questions? Questions? I don't need comments. Any questions? Questions?
I assume that this will be continued until after.
Oh yeah, this is going to be continued for a while until something else happens, because I'm stuck in the mud, not knowing who the appropriate party is to pay recognizance to, who has the authority to bring the landlord and tenant eviction writ against you folks. And I'm not going to presume, nor am I going to guess and speculate in terms of what I find and the statute says is a fact that needs to be determined by this court prior to issuing such an order. Now, any other questions? You need to do what you need to do, Mr. Mackler. Feel free to make the requests as I've stated. You ought to do your best to hustle things along in Superior Court and see what can be done there. Because at this point, this court is really in a box. I don't like it, I will tell you that. I'll tell that to everybody. But it is what it is. All right, the parties are excused. Have a good day. By the way, one final item, discovery. I want everybody to cooperate, regardless of what's going on here. The rules are the rules. I expect everybody to cooperate. And I don't want discovery requests being made, 4 days prior to a trial. You have a fair amount of time to get your stuff to him. And, you don't send it a week before and all this stuff. So I just want a bit of cooperation.
Yes, say a word on that.
No. I'm just asking that you both cooperate under the rules as best you can, okay? That's all I want.
Took some time to read the rules.
What?
I said it took some time to read the rules.
I hear you, my friend. I respect that, I do, but the rules are still the rules. And if you want to proceed pro se, you can, but everybody's going to operate on the same set of rules in fairness to all. All right, your excuse, thank you.
Thank you, Your Honor.
Have a good day. I hope they look okay on the camera. Did you get good pictures?
Very good.
Okay, good, thank you. Just want to make sure.